Alberta Employment Standards Rules. Employment standards, termination, and layoff. Proper notice must be given when an employee quits or an employer terminates or temporarily lays off an employee. Here are the basic rules. Termination is the permanent end of an employment relationship. There are many terms that are used to refer to termination, including quit, resigned, retired, fired, let go, and dismissed. Layoffs are a temporary pause in work. They can end in a recall to employment or a termination. Employees and employers must give each other written notice of their intention to end the employment. Important details for termination notice. Employers can pay termination pay instead of providing termination notice. Notice is not required if employment is 90 days or less. Notice is not required for seasonal or task-specific employment. And notice period length is based on how long the employee has been working for the employer. Employee earnings must be paid within 10 calendar days after the end of the pay period in which termination occurred, or 31 calendar days after the last day of employment. An employer cannot reduce earnings or any other terms or conditions of employment during the termination notice period. Employees cannot be required to use vacation, banked overtime, or banked general holidays during the notice period. Group terminations have additional rules. The Government of Canada requires employers to submit a record of employment, or ROE, for their employees to qualify for employment insurance benefits and leave. Employees and employers should be aware of the following employee rights: termination of employment, duty to accommodate at work, refuse dangerous work. Termination of employment. The Alberta Human Rights Act prohibits an employer from terminating an employee in connection with a protected ground. What does the Alberta Human Rights Act say about terminations of employment? An employer may terminate an employee with cause, for good reason, sometimes called firing, or without cause, for no reason, sometimes called letting go. An employer cannot terminate, with or without cause, an employee if the reason for termination is based on one or more protected grounds. For example, an employer cannot terminate an employee for being pregnant or because of their disability. An employer also cannot terminate an employee for making a human rights complaint. An employer can justify a termination where it is reasonable and justified in the circumstances or based on a bona fide occupational requirement. What are some protected grounds? Personal characteristic of individuals or groups of individuals that is protected from discrimination under the human rights legislation. There are 15 protected grounds under the Alberta Human Rights Act. What is a bona fide occupational requirement, also known as BFOR? It is a standard or rule that is integral to carrying out the requirements of a particular position within a workplace. For a standard to be a BFOR, an employer must establish that any accommodation or changes to that standard or rule would create an undue hardship. What you need to know: 1. An employer cannot disguise a discriminatory termination as something else. 2. An employer has a duty to accommodate an employee to the point of undue hardship. 3. An employer may terminate an employee if it is reasonable and justifiable or based on a BFOR. 4. An employee who has experienced a discriminatory termination connected to a protected ground, can make a human rights complaint within 1 year of the incident. 5. A valid severance agreement or release may prohibit an employee from making an accepted human rights complaint. And 6. Employment standards legislation, not human rights legislation, applies to severance and termination pay. There is a duty to accommodate at work. Employers have a duty to accommodate employees or job candidates because of a protected ground to the point of undue hardship. What is the duty to accommodate? Employers, service providers, landlords, and others have a duty to accommodate. This means making changes to rules, standards, policies, workplace culture, and physical environments to eliminate or reduce the negative impact that someone faces because of a protected ground. The goal of accommodation is to provide an equal opportunity for an individual or group to participate in any of the protected areas under the Alberta Human Rights Act. What you need to know: an employer's duty to accommodate employees or job candidates begins when first advertising a job and ends when the employee requiring accommodation leaves the job. 2. Both the person requesting accommodation and the employer have rights and responsibilities in the accommodation process. 3. Employers who receive a request for accommodation must take reasonable steps to accommodate the person's needs to the point of undue hardship. 4. Employees, employers, and unions, if there is one, must participate and cooperate in the accommodation process. 5. In some situations, an employer can justify its decision to not accommodate someone because it was reasonable and justifiable in the circumstances or it caused undue hardship. 6. The accommodation process is most successful when everyone works together to come up with creative, flexible solutions. Refuse dangerous work. You have the right to refuse work that might put you or others in danger. It's important to know workers have the right to refuse dangerous work and are protected from reprisal for exercising this right. Employers cannot take or threaten disciplinary action against a worker for exercising their rights and duties under the legislation. Workers must report the refusal and their reasons for it promptly to a supervisor, employer, or employer's designate. As much as possible, workers must ensure their refusal does not endanger the health and safety of others. Employers must inspect the hazard. If possible, remedy the hazard immediately. If the hazard cannot be remedied immediately, the employer must stop work, discuss the matter with the refusing worker, and conduct a hazard inspection. Work cannot resume or another worker cannot be assigned until the hazard inspection has been done and the hazard remedied or it is determined there is no hazard. If there is a health and safety committee or representative at the work site, they should be informed of the refusal as soon as possible. How does this work? Workers on provincially regulated work sites have the right to refuse work if they reasonably think there is an undue hazard at the work site or that particular work poses an undue hazard to themselves or others. An undue hazard is a serious and immediate threat to health and safety that the refusing worker actually observes or experiences at their work site. How to address dangerous work. The worker obligations. If you're being asked to do work you think could present a danger for you or another, follow these steps. 1. Don't do the work. 2. Tell the employer, supervisor, or another designated person as soon as possible what you're refusing to do and why. 3. Your employer must investigate and take action to eliminate the danger. This may include the employer finding a qualified worker to do the work or implementing controls. 4. Unless the danger is fixed immediately, the employer must prepare and provide you with a report once their investigation is complete that explains the actions they took to address the danger. 5. Connect with the OHS contact center if your employer won't stop work you think is dangerous or if an undue hazard exists at your workplace. 6. Do other work that your employer assigns you in the meantime, providing you can reasonably do it and it's safe. And 7. Review the written report your employer gives you about their investigation into the danger and the actions they take to fix it. Connect with the OHS contact center if you think your employer hasn't corrected the situation. Your resource is the right to refuse dangerous work. What are employer obligations? If you're an employer who has been notified that your worker is refusing work they think is unsafe, you're required by law to look into and eliminate the danger. If a worker refuses dangerous work, follow these steps. 1. Inspect the undue hazard and take action to eliminate it. In some cases, you may be able to resolve the issue and resume work right away. For example, if you can provide replacements for broken or damaged tools or equipment, or assign a trained and competent worker to a task that an untrained worker is refusing to do. If you can't remedy the hazard immediately, you must stop work, discuss the matter with the refusing worker, and conduct a hazard inspection, assuming it is safe and reasonable to do so. Two, if you have a health and safety committee or representative, inform them of the refusal as soon as possible. Even if you were able to remedy the hazard immediately, they must be informed. The Health and Safety Committee or representative may raise concerns or make recommendations. As an employer, you must respond to these promptly. Three, you cannot resume work or assign another worker to the task until you have done the hazard inspection and either eliminated the hazard or determined that there is no hazard. Four, you may temporarily assign the worker to another job, but at no loss of pay. The worker must be capable to do their temporary work assignment. Five, document in writing the circumstances surrounding the work refusal, details of the hazard inspection, what actions you took to remedy the situation. And six, giving the refusing worker and the Health and Safety Committee or representative, if there is one, a copy of the written report. If you have questions about how to handle a worker's refusal to do work they think is dangerous, call the OHS Contact Center. Contact the OHS by phone at 780-415-8690 in Edmonton. The toll free is 1-866-415-8690.